But I looked at everything. I looked in all. I looked at orders that were entered. I have an order on a motion to withdraw for plaintiff's counsel, an order on substitution of counsel, an order canceling a hearing, and an order on motion to compel. Apparently, they didn't catch anything on a stay.
And this would have been.
I see a motion to stay now that I'm looking at it from back in 2022, but I don't see an order entered on that.
It looks like it's the 26th of April, 22.
Oh, it's docketed as an order granting a motion to compel. I assume that's where compel arbitration. Okay. It's docketed as a discovery order. All right. And what is from 2022? Y'all are still in arbitration on this?
Right, Your Honor. I apologize for that. I picked this case up recently. And we've been doing inspections and trying to get it resolved amicably. I think we're pretty close. So I can't speak for kind of how things went over the last couple of years or so.
So, Your Honor, Elizabeth Stolinas, I apologize, my camera's not working right now, but one of the headaches in this one is Red Stucco and its insurers have exhausted their limits, and so Coverage Counsel has been dealing with over 200 of these single-family home claims, and they're trying to resolve them. So that's kind of one of the hiccups with respect to trial, given the fact that counsel for Red's downstream claims is withdrawing. We would ask that the court obviously grant the motion to withdraw and allow Rodriguez and Medina 30 days to retain new counsel. And if anything, would probably, obviously plaintiff's counsel is not here, but maybe we could set the case for trial in 6 months. Hopefully by that time, this case is just wrapped up and resolved.
So 6 months is going to create some challenges because my dockets in the fall pretty well maxed out except for the September 2nd docket. That's the last one I have available in the fall that has any room on it. And the reason is that I've got September 29th is a jumbo docket created for medical malpractice cases, and it's running, it's a 6-week docket for those large cases. They're already got several cases behind them, but there are multiple large cases. The November 24th docket is Thanksgiving. So those are pretty well maxed out. So I've got September 2nd or you're into January.
Let's roll into 2026.
So I can give you January 19th, 2026.
Let's do that.
And that does have a virtual pretrial on December 16th. Does that work for everyone?
Yes, Your Honor.
All right, here's what I need on the order and the motion to withdraw. I have no problem granting 30 days for a stay of proceedings in order to retain new counsel. This is a corporate entity that needs to be referenced in the order. That is a corporate entity. They must be represented by counsel. Therefore, if they fail to have counsel enter a notice of appearance within 30 days, they may have a default entered against them. So the caution needs to be in the order.
Okay.
And
yes, Your Honor.
Interim contact information needs to be contained in the order. Please don't put anything in the order that says they're required to notify me of anything. They're not. They're just required to retain counsel.
Understood.
And then separately, send me, I don't know who's going to send that to me. Is that Ms. Godfrey, were you the one who was going to send that? Or Ms. Salinas, that's who. So you're going to send that to me. An order setting trial, 3 paragraphs. Paragraph 1 will be, the case will be set for trial on the docket commencing January 19th, 2026. Paragraph 2, the case will have a virtual pretrial on December 16th, 2025 at 1:30 p.m. And paragraph 3, the court will issue a uniform trial order. Please use those exact words. capital U, capital T, capital O. Uniform trial order, that is the old style order, and that's the one that you want issued.
Will do. Thank you, Your Honor.
All right, y'all have a great day.
You too.
Thank you.
All right, next I have Tiralongo versus Magic in the Sky, Florida, 2023 CA 2695, appearance for plaintiff.
Good morning, Your Honor. Ryan Will on behalf of the plaintiffs.
Appearance for defense.
Your Honor, Chris Hill for SeaWorld.
Good morning, Your Honor. Jim Vicarious.
Mr.
Jim Vicarious for plaintiff Talifus, Lindsay Talifus.
Mr. Vicarious, your camera's not on.
Yes, Your Honor. It was on. I'm not sure why it's off now.
Good morning, Your Honor. Robert Booker for defendant Wayne Automatic Fire Sprinkler.
Good morning, Your Honor. Mike Forte on behalf of
Rush for plaintiff Borland.
I'm sorry, say again. It's somebody made an announcement for a plaintiff.
Yes, Your Honor. This is Brian Rush, counsel for plaintiff Borland.
Mr. Rush, you also don't have a camera on.
Yes, Your Honor. I will work on that. Thank you.
Do I have any other counsel?
John Brooks.
Mike Forte on behalf of Nathan's Properties.
John Brook on behalf of Magic in the Sky and the Dell individuals.
I got everyone? All right, folks, I have a motion for leave to file a second amended complaint. Is this objected to?
Your Honor, we've met and conferred. I've had no formal objections. We've discussed this with each of the existing defendants. The purpose is to remove some defendants as a result of settling, and then also to add a couple of defendants to make sure that we had everybody before the statute expired.
Your Honor, if I can comment on, I don't have I know the amendment will likely be allowed by the court. Substantively, we have issues. The concern, I think, globally is just what the amendments are doing to the scheduling. I've tried to hopefully get ahead of that. We have filed a motion with Your Honor to designate the case as complex, which will give you some flexibility. If this isn't complex, I don't know what is under the rule. So we would ask you your preference, honestly, on the procedures. If you would like to just deem it complex, we can then schedule the case management conference. I've also had we've conducted a informal meeting of all the counsel and gotten their input and prepared a proposed case management order that I have attached to the motion. Again, we've submitted that as our proposal to the court, subject to your approval, but didn't know what your preferred procedure would be on going forward with that.
I saw the motion, but I didn't take a close look at the proposed case management order. Has everybody looked at it?
We had a global Zoom call with most of the counsel. I've run it by all of the plaintiffs' counsel. As I understand it, they are all on board. We have modified the dates a couple times and redlined them to accommodate some personal schedules. So we've done our best, but I will tell you, I haven't heard from everybody on this. We've circulated it, but I have not received comment back from some of the other defendants.
So who have you not heard from?
So there's certainly the new people.
Well, the new people who aren't really new people because they were dismissed from the case, right?
No, there are two new parties, Evolution Pyrotechnics and Evolution Pyrotechnics Manufacturing, but the balance are going to be dismissed. We're dismissing 11 plaintiffs as soon as we can kind of clean up the pleadings, if the court permits that. 11
defendants, you mean?
Defendants, I'm sorry, did I say plaintiffs? Yeah.
I didn't see 11 plaintiffs in the case, so I assumed you meant defendants.
Yes, ma'am. Sorry.
So, folks, I don't have any particular problem with designating the case as complex if that makes it easier for you all to coordinate, move things forward. What can't happen, however, is that you just have a case management order. All cases in the state of Florida are required to be under a trial order now. So I need to have I need to, choose the date, which you've said September 2026. The clarification I would need on that is the dockets in 2026 are August 31st, which is 90% in September, or September 28th, which is 10% in September, but actually starts there. So which of those dockets are you talking about? And I need to issue a trial order on them because the dates are different from case management to the trial order.
Late September, Your Honor.
So you're going to have to marry up the dates that are in here because you've got things like you've got a much earlier expert disclosure date, things of that nature. So, and it can't be to the extent they conflict, the case management order applies. You have to literally go through and say, this date will be per the case management order, but this one will be per the trial order, and figure out which ones are going to be covered by which, because we have to have a far greater specificity on dates now than we used to have. So I don't have a problem with anything that's in this case management order. It all appears to make sense. Getting early disclosure of experts is going to be critical in a case like this. So all of that makes a lot of sense to me. That the other dates, things like some of them are the same. Deadline to have Daubert motion served is 30 days prior to the pretrial. That's the same as in the trial order. But you've got a discovery cutoff of 30 days before the pretrial. The trial order is going to say discovery cuts off the day before the pretrial. So you need to go through each one of these and say these will be governed by the case management order and these will be governed by the trial order.
Judge, could we convert this into the uniform trial order? What I tried to cobble it from my last trial order, the last case I had in front of me. So a lot of that is familiar because it came right from your order. So I was trying to match those together.
What I can't do, I don't have an ability to go through that 20-page order and pick and insert your dates. You'd have to type up your own uniform trial order that tracks that and then just says, but here are our dates. It has to have all, or you can take your case management order and put all of the other stuff from the trial order has to be in there. All of the language about what has to happen in mediation, when that has to be done, all that stuff from the uniform trial order. However you do it, it just has to be married up. So I don't have an ability to, I barely have enough time to handle the stuff I've got, let alone trying to create a customized uniform trial order for a case. So you'd have to do that and have a buy-in from everyone on it as to those dates. And that's fine with me, but it can't just be a case management order, which has a whole bunch of dates in it. It has to have all the other language from the uniform trial order so that I know that everybody's operating under the same set of rules.
For now, would it be acceptable to do a simple order designating the case as complex? We then have 60 days to have the CMC and adopt the order.
Well, you have to set your first CMC at either way, and then we have to put this in place at that first meeting. So yes, you can do that. But I need you to still pick for me which of these September dates are you talking about, because I need you to give me the trial date. And the reason I need you to give me that trial date is that the case managers are in the process right now of setting all the cases for trial. Once they set it for trial, you won't have any choice but to do a motion to vacate that order. So if you want to avoid that, then have an actual trial date somewhere in here. So just saying September 2026, they're going to issue you a trial order. If you actually have a date, then they'll probably set that one aside and let me handle it.
If I'm recalling correctly, Judge, it might be Mr. Vicarious. One of the counsel had a conflict earlier in August, so I think the September date would probably be preferred.
That would be September 28th.
Yes, Judge.
And it would have a pretrial of August 25th. You can, so go ahead, send me an order designating the case as complex, and you should have it title that order designating case as complex and setting trial date, and put that in there because that's going to be the flag to the case managers to leave the case alone when they get to it, and not issue a standard uniform trial order on it. And then it should also set the case management conference, the first one that's required under the rules. And then from there, that's what we'll be working on at that case management conference, is this case management order and the uniform trial order. But you can save us all a lot of time by, you all have a conversation about how you're going to make these work with the uniform trial order.
Your Honor, what time on August 25th is the pretrial?
1:30. It's August 25th.
How many week trial docket is it?
2026, so it's not going to be me. I'll be gone from the division by then, but it's going to be set at 1:30. I just can't guarantee that the incoming judge might not want to put pretrial at a different time. It's a ways away yet. At least I don't think it'll be me. I think I'll be termed out this division by then.
How many week trial docket is that?
Right now it's a 2-week docket, but given that it's a fall docket, it's entirely possible that that will be an expanded docket. Do you all need a longer docket in this case?
It's likely, Judge.
Then make sure we talk about that at case management as well. We create longer dockets with some degree of regularity. And so the ones that typically get set for longer dockets are one in the spring and one in the fall, sometimes one in the summer. So there's not a problem with making September 28th a longer docket. It's a longer docket this year. My September 29th docket is a 6-week docket. So it's pretty typical. I just need to make sure we do it.
And Judge, one of the aspects, and maybe we can run this by you now if you don't mind, trying to schedule anything in this case is very, very difficult, just the sheer number of counsels. One of the things that I proposed, and there's been no objection so far, was to adopt the business court procedure rules that we do in some of the construction cases, where we have set aside days for depositions, the last 4 business days of every month. I just wanted to throw that out as that's something that would be acceptable to you if we can run it by all the attorneys.
So I've done it 2 different ways. I've done something similar to that, where you just have days that are set aside where everybody has to be available on those days for whatever's going to be scheduled. And I've also done it with a point person who has to have communication on a regular basis about scheduling of things. So you have just a designated scheduler. For a case that's as large as this, even the point person is probably going to be challenging, because even if everybody's communicating, you're going to have conflicts all over the place. So it probably makes more sense to do it that way. Designate which days are going to be available for this case. And so, if you all agree on that, that's fine. We'll set it out that way. That's one of the workable ways. But when it comes to scheduling stuff, I will tell you that I often tell people, when it comes to scheduling, probably the most convenient and efficient way to do that is to simply come into short matters. When I've got everybody on the link, you all have your calendars, I just get the JA on there and we find a date for hearings anyway, for scheduling of depositions. That's stuff that just has to happen between counsel. But we can go with whatever method you all think works best, but scheduling is critical because you're going to have to stay on track, and the case is large and unwieldy. So if you don't have a methodology for doing that, you're going to wind up with the discovery deadlines not getting met. So I'm fine with that, Mr. Hill. Basically, it's a long way to say, yeah, whichever method you all want to use, and anything that involves the court. Here's what happens. Somebody says, we'd like to have a hearing, a 15-minute hearing on such and such. The following dates are available on the calendar. It takes 4 or 5 days before everybody chimes in and gives their availability. And assuming everybody's available, by the time you get all those back, you contact the JA and she says, I'm sorry, those dates are gone now. Because other people were able to move faster because they only have 2 lawyers in their case. And so, and it just becomes a continuous circle of trying to suggest dates that are then gone by the time you can get everybody's response. So that I can help with, but y'all just come into short matters. And you can designate other people to hold your calendar for that if you want. And I can get you a date right then and there while everyone's on the link, and then you can secure it. So I can do that for you for hearings. I just can't do it for the other stuff you need done. All right. So,
Your Honor, for this case, there is one other motion pending. It's the Talifus motion to amend.
I saw that. Is there an objection to that amendment?
There's I think a general objection from SeaWorld. They didn't take, Chris, what was your position?
Yeah, Judge, I understand the liberality of amendments, so I know they're going to get the leave to amend. I was just concerned about the timing and where it placed us with all of the amendments. I wanted to make sure that, really what I want to make sure is that there's an end date for all these amendments and we don't quick set on a trial. Substantively, I can respond via motion to dismiss or motion for summary judgment.
So, the scheduling, as long as that's a timeline that you all can work with, the main thing about scheduling under the new rules is you have to choose wisely in the first go round. So you're outside timelines, but you're outside timelines because the case is large and complicated. So I don't particularly have a problem with any case that's going to exceed that 3-year time frame that we have to report for cases, as long as I can cogently explain why, and I can with this case. I can't explain car accident cases that are 5 years old. But this is complicated, and there's a lot of good reasons why this case is going to take longer than the average time frame. So I don't have a problem with that. But if this is a trial date that makes sense to you all, I have some concerns about it. I think you're a little short on your timeline, but if you all feel confident that you are far enough along that you can make a date that is, roughly a little less than a year and a half away, okay, you're guiding it, but it sounds to me like you got brand new defendants coming in, and they haven't even gotten started. But that's up to you all. Between now and when we get to that first case management conference, these are important conversations to have because continuances are going to be hard to get, and especially continuances because the case isn't ready. So that's why you may need to take a look at those dockets and see if that actually makes sense. And maybe you're shorting yourself by what I would guess is several months on what you're going to need to have this case ready. But that's up to you. You talk.
We'll speak about that, Your Honor, among ourselves. Certainly, we will take your advice and counsel and consideration with regards to those timelines.
All right. Anything else? So there's no objection to Ms. Talifus's motion to amend, provided you have enough time to get everything handled. Is that it, Mr.
Yes,
Hill?
Judge.
All right. So go ahead and send me an order granting that motion. And Rebecca, that's 23 CA 8736. It's also set for short matters this morning. Talifus versus Magic in the Sky LLC. And as to the other motion to amend, but I agree, we need to get who's going to be defending this case and get that set. So hopefully, Mr. Will, we're getting to the point where you've got the final list of defendants in the case. Are we getting close?
We do, Judge. I think this will resolve it. We're actually past the statute, so we're in that place already.
Okay. All right. So coordinate the case management conference. I think it needs to be done within 60 days under those rules. So go ahead and send me an order designating the case as complex and setting that. It would be advisable in there, but in the order designate the case as complex, the targeted trial date that you all have agreed upon. Those dockets are published all the way through the end of 2027 right now.
Judge, if we aren't able to find it in the next 60 days, can we come back on short matters? Is that acceptable?
Somebody's creating an echo. I just muted Mr. Will. He's the one who's creating the echo. All right. So Mr. Will, if you need to say anything, you have to unmute. But yes, we can talk about it at the case management. Hopefully there's enough going on in this case that you're not going to wind up just suddenly getting a trial order. I just want you to understand if that happens, I can't stop that from happening. There are thousands of cases being set for trial right now. And so it may happen. If it happens between now and the time you get that case management set, we're supposed to have everything under a trial order by April 1st. That isn't going to happen, but they are working on it. So if it happens, we'll just take it up at the case management conference, but somebody's going to have to file a motion to vacate it if you get it. Just know it isn't coming from me. Okay?
Your Honor, could I ask a question?
Sure.
I'm just trying to find out about the dismissal of Magic in the Sky and the Dell defendants, because we're still in this, but I thought we'd reached a settlement agreement, so I can't get any answers. So I'm just looking.
I saw a reference that the settlement reached with Magic in the Sky.
I'd be glad to inform the court, Judge. Our intention is to dismiss the Dell defendants and Magic Sky defendants as soon as the order is entered with respect to the motion to amend. We didn't want to have too many documents moving back and forth and confuse things after the statute. And so now that the court has entered a ruling, we'll get a written order to the court and we'll have a dismissal right on the heels of it for all of the Dell and Magic and Sky defendants.
Okay, so
thank you.
Mr. Brook, if those are your only defendants in the case, if you don't see that by the time of the first case management under the complex rules, we'll take it up that day, but hopefully it'll be done by then.
Thank you, Your Honor.
All right. Anything else I can do for you folks today? All right.
No, ma'am.
Have a
Thank
great
you.
day.
Thank you, Judge.
Thank you, Judge.
Thank you, Your Honor. Thank you, Your Honor.
Thank you, Your Honor. Bye.
All right. Next, I have Jackson versus D&J Relaford 2023 CA 6500, appearance for plaintiff. Appearance for defense.
Yes, Your Honor. Kelly Godfrey on behalf of 7-Eleven Incorporated and MDC Coast 5 LLC.
And Blair Clark on behalf of D&J Relaford Incorporated.
And plaintiff's counsel is here, Your Honor. I don't know if she's having a mic issue, but Ms. McKinnon represents Derek Jackson.
Can you hear me okay?
I can hear you.
Okay. Good morning, Your Honor.
Good morning. I have a motion to continue a hearing on the defendant's motion for summary judgment. Folks, I took a look at this case, and the concern that I have is the case has been pending for quite some time. And the motion to continue 7-Eleven's MSJ appears to, the motion was filed back in December 3rd. I don't see anywhere where there's any notices to take any depositions or actually to do any discovery. Doesn't look to me like there's been any discovery set in the entire case that looks like it would go to the issues in this motion for summary judgment. I saw 2 notices of deposition for 2 law enforcement officers, but they wouldn't have anything to do with the question of whether or not 7-Eleven has any control over this property. I didn't see anywhere where there's any back and forth trying to set a corporate rep deposition for 7-Eleven. So it's a motion, the motion to continue it is saying discovery isn't closed, but I don't see where there's any attempt to get discovery. So let's
Yes, Your Honor. Yes. So there's 2 issues. One was there was a motion for default where an order was entered for D&J.
Defendant though.
Yes. So as far as 7-Eleven, the delay in that regard has been that we still currently don't have the operations manual and I'm sorry, let me just go to it so I don't get off track.
whose operations manual are you talking about? 7-Eleven's or D&J Relaford's?
Yes, 7-Eleven's operations manual with D&J Relaford. So we did file a joint stipulation of confidentiality. That was the big holdup with the operations manual, but an order has not been entered on that yet. So 7-Eleven has agreed to give it to us, but an order hasn't been entered on it yet. And we're requesting that because their motion for summary judgment heavily relies on the issue of agency and control. They're arguing that they had no control over the day-to-day ongoings of 7-Eleven. And there are multiple items listed in the franchise agreement that would say otherwise. But we believe without the operations manual, it's difficult for us to respond and to rebut their argument that they had no control over the day-to-day operations of 7-Eleven.
When did you send me an order on that?
The order was sent.
Because I'm working on, we get about 200 orders a week in, but I haven't seen that order. I've got about 100 orders in the queue right now, but that's not a significant number. That's about half a week's worth of orders.
It was sent to your JA on January 30th.
I'm not.
And she stated she received it.
Hold on. She generally inputs orders in the order they're received. She generally submits them in the order they received. The oldest one I have right now is got a cover letter from February 28th. So not sure what's going on with that. Was there an argument over the form of the order?
No, Your Honor. We agreed on the order. It was sent to the JA on January 30th, and she responded that she received it on the same day.
I'm showing the same thing, Your Honor. I presume that it was simply an oversight, and if I may have a moment to respond, in my opinion, this is a non-issue, but I'll wait until I get the court's approval to respond.
Well, I don't see it here. I can't explain that. I can ask her if she can look for it. You said it was sent on January 30th?
Yes, Your Honor.
All right. What else do you believe you need besides the operations manual to be ready for the summary judgment?
The operations manual, as well as the training materials that 7-Eleven agreed to provide to us as a part of this confidentiality agreement. So in our discovery, we requested training materials such as videos, any type of online training that they use for their employees.
What else?
Those are
here's the thing.
the
Your
main
discovery
things.
cutoff is like right around the corner. So there was a whole list of depositions included in the motion, but I don't know why those wouldn't have been set before.
So that's what I was saying before. Part of the issue is that there was a default entered against D&J, and they were in the process of getting an order entered to overturn that default. So we were kind of on hold as far as setting depositions. We did 7-Eleven did take the deposition of my client, but because D&J was not actively participating in the case, we had to have a second deposition taken of my client. So that's what we were kind of trying to avoid in the beginning, with the default being overturned.
Yeah, but the default was overturned in May of 2024. So, I mean, that's not recent. That happened a long time ago, and I don't see any depositions set of any corporate rep or any of these people after that. So I mean, that's the problem I have, is that it doesn't look to me like there's any effort to conduct this discovery, even though you're saying that you want it. And there's a whole long list of depositions you want, but I don't see a notice of deposition for these people.
Well, no, some of these depositions have been set. The ones with a star next to them do not have dates set yet, but we have begun emailing back and forth about setting the depositions. And our discovery cutoff is May 5th, but we do believe that would be enough time for us to complete at least the most important depositions, which would be the corporate representatives of MDC and 7-Eleven. Their entire motion for summary judgment argument relies on the issue of control and agency, but we have yet to depose these corporate representatives. And I have been emailing counsel to set these corporate representative depositions. And the first response I got was that, they needed more time to find out who the corporate representative was. And so I gave them, I believe it was a month before I followed up again, asking to set these depositions, and I still have not received a response. My last email was on Friday.
So the JA has located an order on amended joint stipulation regarding confidentiality of materials produced in litigation. But she's indicating that this was placed into, so when we get orders in, if the order is for an upcoming hearing, it's placed into the case folder, not into a queue for signature. Did you all have a hearing set on this?
We did not, Your Honor. No. We entered into the joint stipulation, and my client 7-Eleven's policy is that we are not authorized to produce documents until we get the court's order on the stipulation. And if I may, Your Honor, again, I'd like a minute to respond to Ms. McKinnon's points.
Go ahead.
Sure. So when we started off this process, I was told by Ms. McKinnon that she move forward on the summary judgment hearing because she didn't have our franchise agreement. If the court takes a look at our summary judgment motion, it is based on literally one document. That is the franchise agreement between 7-Eleven Incorporated and D&J Relaford. Again, I could not produce that in its complete form until we had this order signed. However, we were at Jeanette Relaford's corporate representative deposition about 2 weeks ago. And the court needs to be aware that the entire unredacted franchise agreement was shared on the screen and marked as an exhibit by plaintiff's counsel. I took us off the record. I asked, where did you get this? And why do you dispute moving forward on my summary judgment motion if you indeed have it? And there was quite a bit of back and forth. But long story short, I was informed by plaintiff's co-counsel, who's not here today, that my predecessor, an attorney that no longer works with my firm, actually gave the full unredacted franchise agreement to plaintiff. And I can tell you, he left the firm in May of 2024. So they have had the entirety of the document, the one document that's referenced in my motion for summary judgment, for 11 months. And because of that, I
need to stop you, Ms. Godfrey. Ms. McKinnon, did you just tell me you're waiting on something you've had for 10 months?
No, Your Honor, we're not waiting on the franchise agreement. We're waiting on the operations manual and the training materials that they're agreeing to provide to us. So the operations manual would outline the day-to-day responsibilities of the 7-Eleven employees that they're contesting in their motion for summary judgment. They're saying they had nothing to do with the day-to-day activities of this location.
Your Honor, I will let the court know that we do not reference the operations manual or any of these training materials. The motion is based solely on this franchise agreement. And I have an affidavit submitted with the motion, essentially just stating, yes, this is a franchise agreement that was in place on the relevant date, which was August of 2022.
And the affidavit is signed by Louis Guzzo, who was not disclosed to us previously through discovery. And we would also like to take his deposition sometime before the close of discovery, because we believe that would go towards their argument of control majorly.
So I'm not sure how an operations manual is going to override a franchise agreement. I can't for the life of me figure out if you've got a franchise agreement that's attached to this motion and says, here's the nature of our relationship, what you're going to find in an operations manual that's going to override that. That is, the franchise agreement is in fact a contractual relationship between these parties. And so there would...
Your Honor, if I may really quickly.
Go ahead.
So number 12 of our motion to continue, I highlight a case that we believe is controlling in this situation, which is Parker v. Domino's Pizza. And in this case, the defendant's motion for summary judgment was granted, but it was ultimately overturned because the court looked at not only the franchise agreement, but they looked at the operations manual and the responsibilities within these documents. So they looked at the big picture to see what elements of control Domino's had over the franchise. So the parties in Parker v. Domino's, this is a situation with a Domino's driver, a franchisee, and a franchisor. And the court in this case looked at not only the franchise agreement, but the operations manual and all the responsibilities that Domino's gave to the franchisee to come to the determination that they were more than just a contractor. There was more control in this situation. And that's essentially what we're arguing as well.
Well, Mr. Kennedy, I'm not really sure what you're arguing because your motion talks all about these depositions. I don't remember seeing anything about the operations manual in here. It was all discussed about the depositions you felt you needed. So it's...
So number 12 and 13? Well, 10, 12, and 13.
Your Honor, I think we may be in a different position if those materials were at all relied upon in my motion for summary judgment. But again, the franchise agreement is the controlling document. Ms. McKinnon and her co-counsel have had the full document for, again, as I said before, approximately 11 months.
Ms. Godfrey, the problem with it is that you and I both know that if I wind up granting a summary judgment and there was in fact discovery that legitimately had been requested that the other side didn't get, then the 6th DCA will be happy to send that right back to me. So that's called reversible error to do that. And there's a truckload of cases that say that. So while it appears to me that the efforts to get discovery in this case by plaintiff has been marginal in terms of this. There's an argument that the operations made. There's no legitimate argument on these depositions. There's just no effort to set any depositions in this case. So not setting depositions and then trying to avoid summary judgment by saying we need 11 depositions when your discovery cutoff is 6 weeks away, that's just lacking merit. So on the basis of the operations manual and the training materials only, I have to grant the continuance. But in Ms. McKinnon, if you want depositions, then I strongly suggest you get them set. You didn't make any effort for 2 years to set these depositions. And now a last minute effort to set depositions not going to result in another continuance of this summary judgment, which they can reset. So I don't know what happened with this order. I have it. It's in a different folder. And all I can assume is there was some misunderstanding or computer glitch that put it into the case folder instead of the orders to be signed. But I'm going to sign it right now. And then you're going to have your confidentiality agreement. When can you produce the records?
As soon as that order is entered, Your Honor, if it's entered this morning, I can get Ms. McKinnon the documents probably this afternoon. If not this afternoon, tomorrow morning.
So my JA has been digging into it, and so for whatever reason, the cover letter and the stipulation wound up in the orders to be signed. I sent her an email back weeks ago saying, I don't have the order. And so she said, and she had responded to me and said the order was uploaded, but it uploaded to a different folder. So she was under the impression that it had been sent to that folder, when in fact it was in a different folder. And so I was still sitting here waiting on an order, but we just located it. So I'm signing it right now. You should be receiving it any second now. Once it goes through, well, actually, it may have to go through the clerk's office before you get it, but you'll get it this morning. So I've already signed it. I've already signed it, and it has now been filed. So that's done. You're going to produce that manual. So y'all get out your calendars because I'm going to find you another date for your summary judgment.
And Your Honor, if I may address a case management issue, this is Blair Clark on behalf of D&J Relaford. I'm in the process of attempting to schedule a motion for summary judgment and was not able to get dates within the time frame of the trial order, as in within 30 days of the pretrial. And I think the timing of my filing is kind of just on the edge of that as well. I believe that there may be additional discovery that would warrant amending and adding to a motion for summary judgment, but I did have enough, I thought, to file based on what we had. So I know I've discussed this with Ms. McKinnon. She wasn't agreeable to extending the deadlines on when summary judgment motions can be heard, but it sounds like we may need to do that anyway today. So I just wanted to bring that to the court's attention and potentially address that if we could.
Let me start by taking a look at your docket. You folks are pretty deep in this docket. So you initially started out about 22 deep in the docket. 1, 2, 6, 7, 8 of the cases above you are confirmed settled or continued, that you're still, and I haven't gone over these recently, there may be more that have settled or continued, but you're fairly deep in the docket. You're going to have rollout from the upcoming docket that are going to be older cases rolling right into this docket, because every time we roll, we have to roll 2 dockets down so that they will be picking up the March. This docket will be picking up the March rollouts. And there's a high likelihood of some 2019 and 2020 cases rolling into this docket. So your likelihood of a trial slot is not great for this docket, but I am not going to grant a continuance of a properly set motion for summary judgment without allowing the ability to have that motion heard. So it's not going to be granted on the condition that now the time's run and they can't schedule it at all. That's not an appropriate outcome. So I will allow the motions for summary judgment to be set, or at least the motion for summary judgment that was filed by 7-11. With regard to the other one, when was this motion filed?
Your Honor, I filed that motion on February 17th.
So you waited too late.
I believe, Your Honor, that it was within, well, if it comes down to getting court dates and I didn't, yes, I did wait too late.
It always has to be factored in.
Right. I understand, Your Honor, and
so
you know,
when is your date on which you could be scheduled?
The court had some availability in the end of April, and I know Ms. McKinnon wasn't agreeable to setting it because it was outside of the court's deadlines, and she brought that to my attention, and she was right. So I would ask you to extend it into. I mean, we have a trial in June. If we could extend the deadline to hear summary judgments until mid-May perhaps, then we'll be able to still call off any witnesses or anything if we need to prior to the trial, if it is dispositive.
I apologize if I'm looking at the wrong item to all involved here, but I'm showing all motions for summary judgment are to be filed and heard by April 4. So I don't know that Mr. Clark, you were untimely there. I also have a forthcoming summary.
Oh, you're untimely if there's no available hearing time before April 4th.
And I understand, Your Honor, and all I can tell you is that I have been doing what I can to move this case forward since we got it. We were the party that got the surveillance video of this incident, which took multiple public records requests, subpoenas, ultimately a records custodian subpoena or a deposition and a motion for protective order filed by the state that they eventually gave us. It was our own video, but it took a lot to get it. We've taken some fact witnesses depositions, and I think we're moving along toward being ready for the trial date. But yes, we are having difficulty with the deadline for summary judgment. And there's other deadlines that are going to be potentially issues as well. Plaintiff hasn't disclosed an expert, though they haven't indicated that they are going to not disclose an expert. There's other issues involved as well, but I think, in terms of being ready for trial, I think we are in pretty good shape for doing that. I've subpoenaed a witness, located a witness in Connecticut. Connecticut, unfortunately, just rejected my subpoena. They require a Connecticut lawyer to sign it, even though they pretend to be part of the interstate deposition compact. They've written their own rule on that you got to hire a Connecticut lawyer to sign the subpoena. So I'm going to have to ask the court to appoint an out-of-state commission for that.
All right, she has April 30th, 10:30 and 11. Can set both of them. That work for you, Ms. McKinnon?
No, Your Honor, I have to object on the record. We have until March 28th to file a response, which we're currently working on. And I just have to object to that based on the possible, I'm blanking on the word, I'm sorry. Our client could be disadvantaged by granting of a motion for summary judgment that was untimely and that shouldn't have been heard. Because at this point, D&J Rutherford has not exhibited any circumstances that would justify the delay in having this motion heard.
Okay, so in the court's discretion, I'm going to allow it to be set as long as it's done prior to the pretrial. So I'm modifying that date. Is there any actual prejudice to you if your response is due by March 28th? That's 32 days after that, 33 days after that for a hearing.
Yes, so I'm stating that the prejudice would be that the motion shouldn't have been heard because they missed a deadline and there are no exigent circumstances here.
Okay, so they didn't miss a deadline, they couldn't get a hearing. And so because they couldn't get a hearing, but their motion was timely filed, they could have had a hearing March 29th. And so But
the order states that it has to be filed and heard.
I understand, Ms. McKinnon. I just told you what my ruling is. So do you have any other prejudice besides the fact that you don't want it heard because they couldn't get a hearing time?
Only if they're allowed to amend their motion.
I'm sorry?
Their file motion.
They can't.
So
amend,
my other
they
objection,
can't amend their motion. If they amend their motion, all the timeframes kick in again. So then they would be untimely. Okay. The motion they filed is what I'm setting for April 30th, 10:30 and 11. Now your continuance of 7/11s is conditioned upon it being set. And so the soonest I can accommodate it is April 30th, 10:30 and 11. So I can go forward on 7/11's summary judgment if you're objecting to them having it set, because you don't get to ask for a continuance and then say, oh, and gosh, it's too late because there's no hearing time. That doesn't work on 7/11's. You're the one who asked for the continuance. Therefore, you are agreeing by asking for that I will be able to set it prior to the pretrial, right?
When you say setting, are you referring to D&J's motion?
7/11's. Let's start. There are two motions. I have two hearing times. Both are on April 30th. One at 10:30, one at 11. 7/11's motion, you asked for a continuance of that. I'm granting your continuance, but I'm granting your continuance on the condition that it is going to be set at a time that is after the time specified in the uniform trial order. As a practical matter, folks, I don't think you're going to trial in June. You don't have a high enough spot to actually get a trial date, but either way, this is still ahead of the pretrial, so it's adequate time. The reason we ask for dispositive motions to be handled 30 days before pretrial is because it stops the jam up in preparation for the trial to schedule motions for summary judgment very close in time to the pretrial, which has a lot of dates tied to it. So that's why we specify that those need to be done 30 days ahead of time. It's not that there's any particular case reason for it, other than a lot of work needs to be done immediately prior to the pretrial, and I don't like to short people on their time for that. So this is still before the pretrial. It's before all of that last minute stuff gets done. There's no particular problem with this unless you have some identified prejudice from this date. So that's what I'm asking you. So 7/11 is going to be set at 10:30. D&J Relaford can be set at 11 o'clock.
And this is April 30th, Your Honor, correct?
That's it. Take it or leave it. That's what I got.
That works for me.
All right, folks, send me an order granting the motion to continue the hearing on 7/11's motion for summary judgment, directing the production of the records that were to be produced pursuant to the confidentiality agreement within, did you say, what was the time frame you set on that?
I said I could get it to her by tomorrow, Your Honor.
All right, I'm going to say by close of business tomorrow. And then do notices of hearing for your summary judgment hearings. Anything else I can do for you folks today?
Nothing else.
All right, and by the way, Ms. McKinney, if you want depositions, because you do have some time now, between now and April 30th, absolutely request those depositions. If you cannot coordinate them with them, come on into short matters and I will coordinate all those depositions for you using their calendars. Okay?
Yes.
All right, you'll have a great day.
Thank you, Your Honor.
Thank you.
Your Honor, briefly before you move on to the next case, I'm here on Rachel Gonzalez versus Michael Allen Hayes. We were set for a motion to compel deposition discovery. We've resolved that motion. We submitted an agreed order. I just wanted to let you know.
I did not see that case. Hold on. I don't have that on here. Did you let the JA know that it was canceled?
We sent in the proposed order last week on Friday.
No, she must have already pulled it off the docket. I'm sorry to leave you sitting there. I didn't have it on the docket for this morning. I only have one more short matter, and that's a different case.
Yeah, no worry. I just wanted to make sure in case it was reached, and because I represent two opposing counsel that I would appear and let the court know.
All right, you're all good. Thanks.
Thank you, Your Honor.
All right, Rebecca, we handled Talifas versus Magic in the Sky. So next I have Huey versus Shavam Associates, 2024 CA 1698, appearance for plaintiff.
Your Honor, I'm sorry to interject. Did you recall the Marrero Molino case?
I do not have that case docketed this morning. What's the case number?
I'm sorry to interrupt. I apologize. The case number is 23-CA-01655-0. Supposed to be a hearing on summary judgment.
CA 1655. That is Delgado versus Logistics Force.
16551.
Okay, sorry.
I think it's not a short matter. It's the 10:15 hearing, if you have that. A summary judgment hearing, 15 minutes.
Hold on. Granada Insurance.
Yes, Your Honor.
Yes, that's scheduled at 10:15.
Okay, I'm sorry for interrupting. I apologize. Thank you. Thank you. I just wanted to be sure I wasn't, jumping the gun or anything.
I just need to get back to short matters. Huey versus Shavam Associates, 24 CA 1698. Appearance for plaintiff.
Good morning, Your Honor. Kristen Grant on behalf of the plaintiff from Workman Injury Law.
Good morning, Your Honor. Jana Thornberry on behalf of the defendant, Shavam Associates.
I have a motion to withdraw as plaintiff's counsel's motion to withdraw.
Yes, Your Honor.
Any objections?
No objection from the defense, Your Honor. We do have a deposition set this week of the plaintiff's ex-wife who we subpoenaed. We'd like to leave it set because we have her served, but otherwise no objection as long as we get good forwarding information for the plaintiff, who I believe he's incarcerated.
Generally speaking, when counsel withdraws, they request a stay of the proceedings that wasn't requested in the motion. What are you asking for, counsel?
We're asking that Mr. Huey have 30-day to retain new counsel on this case and that you allow us to withdraw. I know that deposition's set, but if he does want to, I'd like to give Mr. Huey a chance to retain new counsel to represent him if that deposition go forward. So maybe reset the deposition. I understand the issues in trying to schedule everything in this case, but we would respectfully ask maybe that get reset till Mr. Huey does have time to get counsel, either 30 or 45 days, whatever Your Honor's inclined to allow.
I need to grant Mr. Huey the opportunity to get counsel, a deposition, without counsel and without an opportunity to retain counsel is problematic.
I do believe Ms. Thornberry is correct that he may be incarcerated at this time.
Which means no representation at the deposition. That's the problem. So I'm afraid you're just going to have to reset that depo.
My only other suggestion would be if counsel could stay in through the day of the deposition. I don't know if the deponent will show, but then after that, if the plaintiff then is unrepresented for a period of time during which he has to get a new attorney. I think it's Wednesday, Your Honor. And just as a separate side note, the case is set for trial in October.
All right, so counsel, what do you want to do?
Your Honor, I would, if you're speaking to me, I would request what we originally just requested, to have an order allowing us to withdraw, have counsel reset the motion to allow Mr. Huey time to find counsel to represent him in the deposition of that individual. There may be a relationship between the person who Ms. Thornberry wants to depose and the criminal case that Mr. Huey's possibly incarcerated still on. So with all that being said, I think that he does need counsel, and counsel that can speak to him prior to defending that deposition.
Here's what I got to do. I've got to grant a stay so that he has an opportunity to retain counsel. I don't know if he's going to or not, but what I will do is, as part of the order granting the withdrawal, I will direct that deponent is bound over by the subpoena that was issued. You want to pick a date right now?
To reset the deposition after 30 days, Your Honor.
Correct. If you give me a date right now, you can say the deposition is rescheduled to a certain date and it's bound over to that date.
Yes, I could do, excuse me, I could do April 23rd.
All right, go ahead and put that in the order that the deposit, what's her deponent's name?
It's Ashley Kinsey.
All right, so indicate that there's a 30-day stay, Ms. Grant, there's a 30-day stay of proceedings to allow plaintiff to obtain new counsel, that the deposition of Ashley Kinsey will be rescheduled to April 23rd. What time?
9 a.m.
At 9 a.m. and that Ms. Kinsey is bound over by that subpoena to the new date. Do not put anything in the order that requires Mr. Huey to advise the court that he's going to be pro se. He just simply is pro se if he doesn't retain counsel. And make sure you put his contact information in the order. He needs to have an address. He's incarcerated. I don't know if he has an email address, but there was an email address in the 2 email addresses in the motion. So put those in there. And whatever his last known phone number was.
Yes, Your Honor. Thank you.
Anything else I can do for you?
No, Your Honor.
All right. You all have a great day.
Thank you.
Thank you. Bye-bye.
At the 10 o'clock hearing is Sorosiak versus 52 Grandview LLC.
I'm sorry, Mr. Woodward's here for that first one. The first short matter.
Aaron Marking versus Magic Burgers, Your Honor.
Okay, folks, I set that. Do you have anyone else here for that?
No, Your Honor, and I think I can handle this pretty quickly. The defendant filed a satisfaction of judgment. We stipulated to the satisfaction of judgment.
Yeah, you
And
did,
so
but you didn't do anything about your attorney fee motion still sitting there.
I will withdraw the attorney fee motion and the case can be closed.
All right. I'll put that in the court minutes that the attorney fee motion is withdrawn on representation of counsel. And it would be helpful if you do a written withdrawal of the, it's a motion that was filed on November 16th of 2022. That's what's keeping it from being closed in the clerk's office.
Understood, Judge. Thank you.
All right, Rebecca, do you need me to do an order closing the case, or can you just tell them that?
As soon as he submits what he needs to submit, it should close. I mean, you can do an order, but
yeah, it should close. I'll do it.
I can watch it though. If he wants to submit what he's doing to get it closed, then I can watch it and then let you know if the order needed.
I'll do an order to close it. All right. Thank you, Mr. Wood.
Thank you, Judge.
All right. Do you have anybody else on the link who believes they had a short matter this morning? All right. The 10 o'clock case, Sarasiak versus S2 Grandview, 2023 CA 9204. Appearance for plaintiff. Appearance for defense. So, Rebecca, this case scheduled for a motion for summary judgment, but there's a mediator's report from February 19th saying that the case is settled. I don't see a settlement status that they were required to set. So let me ask Jess how she wants to handle that. All right. Ten 15 cases, Granada Insurance versus Fast Track Logistics LLC, 23 CA 16551. Appearance for plaintiff.
Daniel Schatz for Granada Insurance Company.
Appearance for defense.
Matthew Smith for Christine Muriel Molina.
And I believe we have a court reporter.
Yes, that's Dana Lumpkin with U.S. Legal Support.
All right, this is Granada's motion for summary judgment.
Yes, Your Honor. Good morning. We're here today on a summary judgment motion in an insurance coverage declaratory judgment action concerning coverage for claims and a resultant lawsuit arising out of an October 18th, 2021
Mr.
automobile
Schatz,
accident.
I read the file. I know why you're here. Let's just talk about your argument and their response. They're arguing that they need more time to their investigation of this case.
Sure, I can jump to that point. I mean, the coverage issue is that this particular policy only affords coverage for approved drivers, for certain drivers. There's 3 approved drivers that are set forth on the insurance policy. So this lawsuit was commenced 2 years ago to determine whether or not one of these 2 approved drivers was on the policy. Granada's insured has defaulted and been deemed to admit that one of the approved drivers was not involved. Ms. Molinas has filed discovery responses saying she has no evidence or basis to prove that it was an approved driver. Discovery closed on January 26th, and as the court knows, under Florida law, a moving party can move on the basis that there's no admissible evidence to support the non-moving party's burden of proof. Under Florida law, the burden is on the insured or a claimant to prove that an insurance policy affords coverage for a claim. I cited those papers. This endorsement modifies the insuring agreement, and so it's the claimant's obligation to come forward with some evidence that their claim involves an approved driver. I cited those cases as well. In the Varmec case attached as Exhibit E to my motion, Judge Nash in Hillsborough ruled as follows.
Schatz, can I interrupt you?
You may.
All of that, I'm aware of all of that.
Okay.
The enforceability of it, all of that. But the question remains, and I couldn't find anywhere in this case, who was driving which car? It sounded like I couldn't find any indication as to who the driver was, whether or not that information has been disclosed, obtained. I assume somebody knows who was driving that car. I didn't see on the motion for summary judgment affidavits from every single one of the approved drivers saying that they're not the driver or any indication as to which car it was. So it's looked to me like the situation is that they can't establish who was driving the car. So therefore, you're claiming that they can't meet their burden of proof on it. But the objection is a discovery objection. And so that means that if you convince me that them having additional discovery time isn't going to make any difference because, for instance, we only have 4 approved drivers. And here's the affidavits of all 4 of them. They were not the driver. I didn't see that in the motion. Did I miss that?
No, Your Honor. 3 drivers. You did not miss that. I don't believe that's my burden, but that's true. And I guess there is no motion. There's no motion to continue. You know, there is an argument that there's needed discovery. There's no motion to extend discovery. Discovery's expired. There's no motion to continue the summary judgment hearing.
Discovery's not actually expired because what you have is this case management order.
Right.
And the case management order gave 450 days from the date of the complaint to complete discovery. But as a practical matter, we all know that that's not how that worked. How that worked under the old rules was that you had your case management order, which was a kind of warm up for the new rules. And then at some point, case was at issue, somebody did a notice for trial, you got a trial order, and the trial order set all new discovery dates, and those new discovery dates would cut off your discovery the day before the pretrial. That hasn't happened in this case because you don't even have a pretrial set in this case. So as a practical matter, yes, discovery expired under the case management order. And I'm not actually even sure that that's true because the case was filed November 2023. Because of, I didn't do the math, but 450 days after November 3rd, 2023 would be somewhere around now, right?
In terms of for the discovery cutoff, I had calculated it as January 26th, I believe. But if that
that can't be right because there's only 365 days in the year. So case would have been a year old in November of 2024, so that can't be right, but I'm not sure. It's sometime around now would be my guess, is when that case management order would run.
So I guess the other argument, and I think I see where your judge is where you're going to rule, and that's acceptable and fine. And I'm, if this is not an actual deadline and we have time to conduct discovery, that's fine. And it sounds like my motion may be denied without prejudice. But that brings me to my second concern that I think we just need to address, is that his argument is also that this discovery will be borne out in the underlying lawsuit. But the underlying lawsuit, my client is not a party to that lawsuit. He's made no effort to conduct that discovery here. If he's
I know, I have them all the time, Mr. Schatz. I have the exact same scenario. We got a personal injury case, and then I separately have a deck action filed based upon the fact that some 16-year-old driver was driving the car and they were never insured. I get that all the time. The question here is whether or not there is no dispute of material fact such that summary judgment is appropriate. And so you absolutely have a policy that has significant limitations. And if you brought to me something that says, look, Judge, we don't know for sure who was driving this car, but here's the people who weren't. And so there is no dispute of material fact. It doesn't matter how much more discovery they do. I'd be with you. If you came back and said, Judge, here's the car that was involved in the accident, and there's no dispute, it's not covered on this policy because only certain vehicles were covered, I'd be with you. But when you come to me and say they haven't established who was driving or what vehicle they were driving, and I've got discovery not completed yet, I cannot find that there's no dispute of material fact. How do I know that they aren't going to finally get answers to what they need and find out that that the car was covered under the policy and it was one of those approved drivers? I don't know what the circumstances are, but until they have the opportunity to do that, the law is going to say that summary judgment is premature. But more importantly, while you have this cutoff of discovery, it's 450 days after the filing of the complaint, but it actually says right in there, additional disclosure and discovery deadlines will be established by the uniform order setting pretrial and trial in the case. You don't even have that order yet. When you get that order, it's going to set your discovery cutoff as the day before the pretrial. So that's the circumstance that I have here. So yes and no, we had these deadlines in these old case management orders. As a practical matter, they were nothing more than the Supreme Court's warm up for the new rules that took effect January 1, where we now actually have case management and trial orders married together, and they actually have dates that are enforceable and meaningful. So we've just been practicing since 2021, and that's where we are with this. So now, your case does need to be set for trial. That has to happen. And right now, case managers are picking up every case in the state of Florida and putting them under trial orders all over the state because we're supposed to now have all cases set for trial. Have you all discussed when this case should be ready for trial? I understand you're going to go forward on summary judgment, but if they determine that they've got some suggestion that it was an approved driver in an approved vehicle down the road, when would the case be ready for trial?
I think about a year. I mean, I guess it really depends on how quickly, within a year's time, I would think it should be okay.
All right, what about January 2026? Mr. Smith, that work for you?
Let me check my calendar real quick, Your Honor.
And to be clear, if Your Honor will indulge me, the issue was precisely that discovery hadn't closed. If we were standing in a situation where the discovery was cut off, and I still argued that the burden had not been met, the outcome may be different. But today the ruling is based on the fact that there's still time to conduct discovery. Is that correct?
Correct.
Okay.
Yes, Your Honor. My schedule is clear for January of 2026.
All right, that work for everyone. And here's what I need from you all. Mr. Schatz, you're representing the plaintiff in the case. So I'll ask you to send me that order. I need a 3-paragraph order from you. It needs to be an order setting trial. Paragraph 1, The case will be set on the docket commencing January 19th, 2026. Paragraph 2, the case will have a virtual pretrial on December 16th, 2025 at 1:30 p.m. Paragraph 3, the court will issue a uniform trial order.
Okay.
All right. That'll get your case set for trial. That will set your new discovery cutoff at the day before the pretrial on December 15th. It's a practical matter, Mr. Smith. This is a limited policy, and so it would behoove you to get moving on determining who was driving that vehicle and what vehicle were they driving.
Yes,
You
Your
can
Honor.
set discovery either in the PI case or in this case, but either one, you're going to need to do that because at some point when you've had an opportunity to do that discovery and you're now on notice that they're seeking summary judgment on this. So even if your discovery hasn't cut off until December 15th, when they show up here in September and say, come on, Judge, you know, he's known ever since March that this was the issue and he hasn't done anything to establish who was driving the vehicle. I'm probably not going to give you additional time for discovery. I need to see that you're actively working to identify who the driver was and what vehicle they were driving. Because just having a cutoff that hasn't happened doesn't mean you're going to get up until that last day to do it. You're now on notice that that's the question that they've thrown on the table, saying that you have not established that it's a covered driver in a covered vehicle, and that's going to be critical for you to move forward on at this point, okay?
Yes, Your Honor. I thank you. I appreciate it.
All right, folks, we'll see you on the next round. Have a great day.
Thank you.
I just wanted to say real quick, I was your internship right before the COVID pandemic, and I just wanted to say it was nice to see you, Your Honor.
It's good to see you too, Mr. Smith.
Have a nice rest of your day.
You as well. All right, the 1030 case is Rodriguez versus McKinley Companies, 2022 CA 11062, appearance for plaintiff. Appearance for defense.
Maham Sharik on behalf of the defendants, Your Honor.
There's a court reporter, Your Honor. Good morning.
I see Mr. Sotomayor, but I'm not hearing him. Mr.
I'm
Sotomayor?
not hearing him as well.
I don't have any audio on you, Mr. Sotomayor. My suggestion, Mr. Sotomayor, would be that you should mute your audio on your computer, call in, have your audio through your phone.
Oh, let's see here.
I have audio now.
Can you hear me, Judge?
I can.
Can you hear me, Your Honor?
Yes, can you hear me?
Yes, I can hear you loud and clear. I apologize, Judge. It's been a struggle with IT and these
All right,
computers.
I have a defendant's objection to a notice of production from non-party and a motion for protective order. It appears to me that plaintiff wants to use the defense CME doctor. Am I correct?
Yes, Judge, I want to get information from the CME physician that is now not going to be called by the defense. I did a notice of filing on Friday at about 4 o'clock with a couple of cases, Judge. The Broward County versus Cento at 611 Southern 2nd 1339, a 4th DCA case 1993, as well as Sun Charm Ranch Inc. versus City of Orlando at 407 Southern 2nd 938. That's a 5th DCA case in 1981. Our basic argument here, Judge, as you well know, is that the doctor that the defendants chose did more than just consult. He, in essence, forced my client to appear for a plenary compulsory medical examination on August 12, 2024 at 3 p.m. He examined my client. He invaded my client's body integrity. It's much more than just a consulting role, and they can't now cloak him under a blanket of consulting when he was the CME doctor. And just because perhaps he might have something that they don't want to hear, they're trying to block me from getting that information. We feel this is not unlike when the defense issues all subpoenas to get every single medical record of the plaintiffs since they were 12 years old and any subsequent injury events that they are entitled to. We are entitled to this as well, Judge.
Response.
Your Honor, first off, I do want to point out procedurally, this hearing was noticed by plaintiff pursuant to our objections. However, Mr. Sotomayor did not prepare a motion as it's required by Florida Rule of Civil Procedure 1.100B, which specifies that an application to the court for an order, which includes requesting a hearing, must be made by motion. So I want to bring that up first. I don't believe plaintiff has standing today to argue our motion or argue against our motion on those grounds.
I'm sorry. He's called up your motion, right?
Yes, Your Honor.
Any party can call up a pending motion, but why wouldn't he be allowed to call up a pending motion?
It's, Your Honor, I've had issues where I've objected to notices of non-party production, and I was told that I didn't have standing to make an argument on another party's notices of non-party production. So
I'm sorry. I'm confused by what you're saying to me. If either party files a motion and they do not withdraw the motion, the other side can set it for hearing. You may not have standing to call up an objection filed by a third party, if they would have to call that up. But if you've got a party's objection or a party's motion, they absolutely can call it up.
Okay, Your Honor. I'll proceed then. Thank you.
Okay.
So just for some background, this case arises out of an alleged slip and fall. We retained Dr. Schwartzberg, an orthopedic surgeon, as a non-testifying expert to assist in facilitating the evaluation of plaintiff and to help facilitate settlement discussions prior to mediation. Plaintiff prepared a subpoena seeking our experts' opinions, reports, and documents. I do want to note, Your Honor, we never disclosed this expert as an expert we intended to call at trial. And there was a CME order that was entered in compliance with the objections put forth by plaintiff's counsel. Within that order, there were no discussions about the necessity of defense to turn over any documents or a report produced by the expert. Again, I note that this expert was never disclosed, and once we consulted with the expert, we ultimately decided that we would not be moving forward we ultimately decided that we would be just using the opinions for causation. There was never an intention to move forward with that expert for trial purposes. Pursuant to Florida Rule of Civil Procedure, Your Honor, 1.280B5B, a party may discover facts known or opinions held by an expert who's been retained or specially employed by another party in anticipation of litigation or preparation for trial and who is not expected to be called as a witness at trial, only as provided in Rule 1.360B, or upon a showing of exceptional circumstances under which it is impracticable for the party seeking discovery to obtain facts or opinions on the same subject by any other means. And then Rule 1.360B closely follows the federal standard, which states that ordinarily a party may not, by interrogatories or deposition, discover facts known or opinions held by an expert who has been retained or specially employed by another party in anticipation of litigation or to prepare for trial and who is not expected to be called as a witness at trial.
So let me ask you a question. You've got an agreed upon order for a compulsory medical exam of the plaintiff. And now you're saying that they're not disclosed. They absolutely are disclosed because it was a CME. And you've got case law filed by Mr. Sotomayor on that exact same question about whether or not the CME doctor can be called, right? I need you to address the cases.
Yes, Your Honor. So the cases that were brought forth by Mr. Sotomayor, Broward County versus Cento, it's our position that that case is not applicable and it's clearly distinguishable to the facts in our case. In that case, it states that the expert was disclosed as a witness intended for use at trial. And then they later deleted the name of the expert from their expert disclosure. While we may not have disclosed the expert, while the expert may have disclosed by way of the order for CME, we did not intend to use this expert at trial, or that expert would have been listed in defendant's expert disclosure. The other case that was cited by Mr. Sotomayor, Suncharm Ranch, that's a clearly distinguishable case, Your Honor. It involved the interests of landowners and eminent domain cases, and the court took that into consideration in their ruling. We don't have the same interests here, Your Honor. It's our position that if we're following the cases that were cited in defendant's motion for protective order, which require that where the party seeking discovery needs to prove that exceptional circumstances exist in order to be able to obtain work product. Here, it's our position that exceptional circumstances don't exist. Plaintiff has their own hybrid orthopedic treating doctors who will provide opinions regarding the extent of plaintiff's injuries. Plaintiff's counsel was also present at the CME. We also permitted a videographer to be there. So it's our position he has all the materials that he needs, and any other material that goes beyond that was used solely for consulting purposes and falls within the realm of work product privilege, prepared in anticipation of litigation.
So, Mr. Sotomayor, if they never actually listed the doctor as a witness, why does the fact that he conducted a CME change him from a retained expert, or from a consulting expert to a retained expert if they never actually listed him?
Your Honor, because they label him something doesn't mean that he is that thing. You see, a consulting expert, and counsel said it maybe 2 or 3 times, in anticipation of litigation. We are in litigation. And they made my client appear for a compulsory medical examination pursuant to the rule.
Let me clarify my question to you.
Yes, sir.
And by example, if they had hired an expert, or either side had hired an expert to go take a look at land, and they might have to have an order, they might have to disclose that that's occurring if the land is under the control of the opposing party, and they go out, they take a look at it, and they give them some advice about what they can and can't do with land. That's not different from an analogous perspective to, you can hire a consulting expert, you can ask that consulting expert to take a look at the plaintiff and give you some advice about that if you've never actually listed this expert or this individual as a witness in your case, aren't they still just taking a look at the plaintiff and getting some information and advising them, which is what a consultant does? And so the fact that there was a CME that was done by an agreed upon order, I'm not sure why, but they never actually named the CME doctor in their expert disclosure or their witness list. So how is it different? Just because it was inconvenient for plaintiff, but it's still, they still didn't actually put them on a witness list anywhere.
Judge, this is not an anonymous view of land prior to any litigation for advisory purposes. This is a mechanism that was used pursuant to the procedure rules to force my client to appear somewhere. And their expert, by their setting this compulsory medical exam, is in essence a disclosure, Judge. And my colleague, my esteemed colleague, is misreading the case law that I submitted, because it deals with a little more than in condemnor of land. The principle of the law is there, that we can get access to this information because they forced something more than just looking at documents. There's another case called Rocca, R-O-C-C-A versus Rones, R-O-N-E-S. The site escapes me, but in that case,
I
a
gotta have
similar
the
situation.
I gotta have the site. Give me the site if you're going to start talking about a case.
Okay. I don't have it with me, Judge, but if the court will indulge me, I can provide it to the court. Rocca was, in essence, a case where an expert was used, but the expert simply went over financial documents in reference to spreadsheets and calculations. That expert did not have any more intimate involvement in the case, and the court in Rocca protected that expert from being deposed by the opposition. That is not what we have here. We have an invasion of someone's body integrity using the compulsory medical examination rule in litigation, not before litigation. I think it's different, Judge. I think that this is, in essence, an expert that they fully intended to use at trial, but got some bad news after the CME examination. We should be able to explore this like the defense can explore any medical doctor that's ever seen the plaintiff in his entire life.
And no one has an actual case involving a CME doctor.
I couldn't find one, Judge, but I have the site for Rocca. It's 125 Southern 3rd, 370, 3rd District case, 2013. And again, we're talking about the level of intrusion here. It is not merely a consulting expert. This is something more right in the midst of litigation. We have a trial date and a pre-trial date on this case, Judge. We're on for trial June 9th with a pre-trial of May 6th. This is in litigation. It is not before. Your Honor, I can comment on the case cited by the defense, Bailey versus Miami-Dade County, but I'll wait for the court.
Give me the citation for that case, please.
Which one, Bailey?
Yes, please.
Bailey is 186 Southern 3rd, 1044. This is 3rd District, 2015. And in Bailey versus Miami-Dade County, that case is highly distinguishable from this case, Judge. That was a medical malpractice case. The decedent, his estate, sued Mount Sinai Hospital and Miami-Dade County. They sued Mount Sinai Hospital first under medical negligence, medical malpractice, which requires in pre-suit an affidavit from a physician indicating some deviation or breach of the standard of care. Later on, they added Miami-Dade in simple negligence because Miami-Dade sent EMS people out in conjunction with the hospital employees, and while they were moving the decedent on the gurney, he falls and injures himself and later expires. The plaintiff in Bailey dropped because they settled with Mount Sinai. So all that was left was a direct negligence against Miami-Dade County, rendering that physician who gave the affidavit free suit irrelevant. That's not what we have here. We have a personal injury lawsuit where the question is causation, injury, damages. They forced my client to appear for their CME examination in the midst of litigation.
Do you have this doctor listed as a witness for you?
Not yet, but I will be amending my witness list. But I need this information so that I can set his deposition.
You're not amending your witness list now.
Well, Judge, that puts me in a precarious position, Judge, because this is truly exceptional circumstances. I have no ability to get the substantial equivalent of this information other than through Dr. Schwartzberg.
Your Honor, if I may, the substantial equivalent of the information would be plaintiff's own experts or treating physician's analysis of his injuries. Just because defense retained an expert to get an understanding of plaintiff's injuries, which we are entitled to, doesn't mean that there are any exceptional circumstances that exist that prevent plaintiff from having an understanding of the same orthopedic injuries from his own doctors.
Yeah,
Your Honor,
I'm going to sustain the objection, and the ruling will be that you cannot get this information. This is a pure consulting expert at this point because they didn't name him as an expert. Had they named him as an expert, either party can call him. Had they named him as a witness at all, either party could call him. But he hasn't been named as a witness by either side. Witness lists, the date for disclosure of witness lists has already passed in the case. Therefore, nobody's going to be able to name him as a witness. And there's no unfair prejudice to the plaintiff in this case because the plaintiff has their own doctor. The defense isn't going to have a CME doctor if they don't call this guy because it's too late to get CMEs too. And so at this point, you've got your doctor, they aren't calling theirs, and they're using theirs as a consulting expert. They never named him as a witness, and therefore an appropriate analysis of the fairness and prejudice dictates that this would not be appropriate to allow plaintiff to obtain the information that they did in their research of the case and their hiring of a consulting expert. And so while it is unfortunate for plaintiff that there was a CME actually conducted and that's inconvenient, I don't think that that is an invasive procedure. I'm very sure that there was actual part of the agreed order was that it wouldn't be invasive, but it's time consuming and inconvenient, but does not rise to the level of a prejudice that would warrant invading the work product privilege that they're asserting, that they're entitled to assert on a consulting expert. And because of the fact that they never named this doctor, he is in fact a consulting expert for them. Therefore, the objections will be sustained and the motion for protective order will be granted. Send me an order to 33orange at 9circuit.org. Make sure to include the date and time of today's hearing. Anything else I can do for you folks today?
No, Your Honor. That concludes my business. May I be excused, Your Honor?
You can. Have a great day.
You too.
Thank you, Your Honor.
All right. Next, I have Sutherland versus Stevenson, 2023 CA 2311. Appearance for plaintiff.
Nicholas Studo on behalf of the plaintiff, Your Honor.
Appearance for defense.
Good morning, Your Honor. Paula Campione and Mike Grimley on behalf of the defendants.
And court reporter Alessandra Dapra with Milestone Reporting Company.
All right, folks, so I took a look at what you've got going on in this case, and it appears that you were set for trial at an earlier point in time. And deadlines were established for that point in time, which was a February trial docket, I believe. You got rolled off of that docket onto a later docket, and the order that reset the trial didn't extend any of the deadlines. So you've got disclosures, an expert disclosure that was late, but not really very late. And it, with regard to this trial period, but late for the prior trial period. Am I getting that correct?
Yes, Your Honor. The motion to, yes, Your Honor, that's correct. Just as a note, Also, defense has a pending motion to continue. It's not set to be heard till the 27th of March, but I hold a high likelihood that it'll be granted. It's based on defense counsel's getting actually married during that trial period.
I saw that.
But beyond that, Your Honor, this was disclosed back in December. It's a simple accident reconstruction specialist. It falls on the plaintiffs. It was our fault not disclosing an accident reconstruction specialist in all candor. I did not think the facts warranted it. Defense disclosed a biomechanical engineer, which I don't think we need. Listed two names, but wrote the paragraph as a biomechanical engineer. Then in mediation told me that they would only be calling an accident reconstruction specialist, which in fairness to the defense was one of the two names listed, but not the top name on the list. But at that time, as soon as I found out, I began as quickly as I could. Estes is a large trucking company. It took me 2 weeks in order to find conflict checks for multiple experts. And as soon as I found one, I disclosed it. That was disclosed back in December. Now with an April trial date, which I anticipate will be pushed back even further, just simply is no prejudice. And they have an accident reconstruction already. It's not that they'd have to then go get somebody to rebut my people. I've also given them dates for depot, Your Honor.
Response?
Good morning, Your Honor. So the plaintiff's experts were due September 17th, which for the prior trial order, and plaintiff listed 15 non-retained experts. It was no surprise. We've always had an accident recon. We filed our expert witness list timely. And then after mediation, for some reason, it finally was on plaintiff's radar that we had an accident recon and they had no one. And so plaintiff sought to amend late. And it is late, Your Honor. It was almost a 3-month late disclosure. What is conspicuously absent from plaintiff's motion is good cause. We were on your February docket. We were all ready to go. We're getting rolled. And it is going to prejudice the defendant if this motion is granted. First of all, our pretrial conference for the next docket is tomorrow, I think, Your Honor. And for continuance has not been granted. And Mr. Grinley could probably, he's lead, could try the case without me if necessary. Plaintiff has listed a mechanical engineer and a
Campion, are you pushing for a continuance or not? I mean, you're arguing both of them right now, saying we're prejudiced because we're set for trial, but you have a motion pending saying that you have a conflict with this trial based upon a wedding. So are you withdrawing your motion to continue, or are you proceeding forward on that so that we're talking realistically you don't have a pretrial tomorrow?
No, Your Honor, of course I would like to try this case. I've wanted to try this case. But our prejudice is not solely based on my personal conflict that has arisen because we were rolled. The other, prejudice, Your Honor, is that there are two additional plaintiffs, experts seen by the plaintiff. One's a mechanical engineer, one's a biomedical engineer. And I don't discount with what my colleague said about dates. I did not see those dates for depositions, but no reports have been produced, if any. And Your Honor, we would have to retain rebuttal experts, which we've not done yet. We would definitely need a rebuttal biomedical engineer because the plaintiff is seeking leave to add 2 additional experts, not just one, not just a rebuttal 2 hours. Again, this disclosure was 2 months ago and no depots have been taken, no reports have been issued. And I understand, yes, we're probably going to get rolled, but with the trial order, Your Honor, and the fact that the courts are now, under pressure to try all these cases, if we're going to continue to move the goalpost every time we get rolled, then effectively, why do we have a CMO or a trial order?
Your Honor, first I need to respond to something. I had a conversation with Ms. Campion and Mr. Grimley, and she's well aware that the second expert, the biomechanical, I listed in rebuttal. They told me that they are not calling their biomechanical. Based on that representation, I'm not trying to add the biomechanical anymore. They know that. We've had this discussion.
Who are you trying to add?
Just an accident reconstruction specialist named Chase Nailers. That's the only person.
So you want one expert that you didn't previously name, and you named Mr. Naylor
On December, well, officially on December 30th, Your Honor.
Did you provide depot dates for Mr. Naylor when you disclosed them?
No, not at that time.
Why not?
I did not have any. I did not have any from him, but I have now. That's the best that I can answer the court.
Did you ever ask for an extension of time or request leave or request any relief from
That was my
the
motion.
deadline?
My motion was to allow me to amend my expert witness disclosure and witness list. I thought that was sufficient. If it wasn't, then I apologize.
Well, asking for a motion to amend the expert disclosure was filed, your motion was filed, let me find it.
December 30th.
So let me ask you this. You're on a trial docket. You're trying to add an expert in the end of December. Why are you here March 10th? Why were you not in short matters in January to discuss?
My office has tried many times to get dates, and I did have a date 3 weeks ago. Defense counsel can agree. I got the stomach norovirus, Your Honor. I was not able to make the hearing. I had to cancel the hearing.
So for the last 3 months, you all couldn't find a single short matters hearing date that you could agree on to get in here and discuss this.
And I'm sure defense counsel can agree. We have a couple of motions. We've gone back and forth a lot with due diligence, trying to get on as fast as we could, Your Honor. And I understand now the secret, like what we're trying to do is just set case management conferences as much as possible when we have these issues, trying to amend to the new rules as best that we can. But it doesn't, and the argument is, Your Honor, we filed it. There is no prejudice after the case got rolled. That was outside of our power, regardless of whether the continuance is granted or not. It's an accident they do not have to hire an accident reconstruction specialist. They have one. They've already told me that they have one. It's to rebut their accident reconstruction specialist. That's it.
So I guess I'm back, Ms. Campione, to you have known about the accident reconstructionist since December 30th. You have your own accident reconstructionist. You do need a depot, but for whatever reason, you all couldn't seem to get in here to talk to me about adding this expert for 3 months. And so where's your prejudice at this point on the accident reconstructionist?
Well, with regards to the accident, well, first of all, Your Honor, we're now we're being heard now in March, and it sounds like Your Honor will be inclined to grant the motion for continuance.
Don't misunderstand me. I'm not crazy about the friction between our directives from the Supreme Court that we put case management orders in place and then we strictly enforce them. That's in the new rule. And then banger. And it just sits out there and says, you got to weigh the prejudices. And those are two very conflicting messages that we get. And in a situation like this, where there's a deadline, sure, technically that deadline was blown. That deadline was months ago for a prior trial docket. And you are absolutely right. There was no extension of those deadlines, and they didn't ask for an extension of those deadlines, and they should have, but they didn't. But I'm still left with Binger. So this isn't me thinking this is a great idea. I am absolutely 100% with you. They had a deadline. They blew their deadline. They didn't ask for an extension of time for it, but I'm still stuck with your case rolled once and it's gonna roll again. And so when it rolls again, there's plenty of time to address this. You already have your own accident reconstruction person. So there isn't really any identifiable prejudice to allowing them, is there?
No, Your Honor, but there, again, my colleague has not offered any good cause. He practically admitted that he just forgot to do it. And now it is going to completely change the landscape of this case. So in addition to additional depositions, I think we're definitely going to have to remediate this case. Because at the time, we mediated, it was a situation where they had no liability expert and we did. And now, the positions of both parties changes.
I agree with you that it creates some additional complexity for it. I think that, and so let me talk about the elephant in the room, which is where are you wanting to move this trial?
The plaintiff would just defer to the defendant, Your Honor.
Yeah. So it was most likely your next trial docket after April 14th, Your Honor.
So the May 12th docket is available. It has a pretrial on April 8th. Is that going to be a problem for you?
Mr. Grimley could go to, I think Mr. Grimley could go to the April 8th.
Well, yeah, I have a prepaid vacation that's from April the 30th through May the 19th.
So you can do the pretrial, right? Oh, wait. So that's through May 19th. So you can't do May.
That's right, Your Honor. I thought you were right. Sorry.
I was asking about the pretrial, but you can't even do the trial docket. So the next docket after that's June 9th with a pretrial on May 6th. So Mr. Grimley can't do the pretrial. Ms. Campion, can you do the pretrial?
I can. Yes, Your Honor.
That work for everyone?
Acceptable to the plaintiff, Your Honor.
Now, with regard to your expert will sit for a depo within 30 days or your expert won't testify.
Okay. I will make sure that happens, Your Honor. We have a second motion on here. The first one took a long time, and honestly, I had 2 points to the second motion that I have listed, Your Honor. Just for the record, it's a motion to strike their medical bill coder. The first reason is now moot, in my opinion. I wouldn't in good faith try to make the argument, seeing as how you've granted it. It had to do with improper disclosure. The second argument, basically a Daubert, and I have already used 10 minutes, so I would ask for leave of court to be able to reschedule a Daubert hearing on that, Your Honor.
Your Daubert hearing needs to be set 30 days before your pretrial. Your pretrial on your new docket is May 6th. How long, you're going to do a billing and coding Daubert hearing? How long a hearing do you need?
That one, but I mean, honestly, I'm sure Your Honor's familiar with the arguments both sides. I'm going to say, I'd say 15 minutes, 30 at the heaviest. I just feel like I know this was only 15 minutes and So
if you're doing it as a motion in limine, then you can do 15 minutes. If you're doing a pure Daubert, that's an evidentiary hearing.
It is technically it is a motion in limine, Your Honor, trying to limit out portions of the testimony based on her methodology, but portions of it we agree she can testify to.
And you've done a meet and confer on your motion?
This was filed prior to that requirement, but I can if Your Honor would like me to.
So, folks, I'm not going to tell you anything you don't already know. There's a truckload of case law on billing and coding people and what they can testify to. Y'all need to take a look at that case law, talk about it, and decide where there is a real dispute if you, in fact, want to do it in a 15-minute hearing. But I'm not going to be able to accommodate a Daubert hearing this morning because my morning has gone off the rails so badly. And I have an 11 o'clock hearing that's just patiently sitting here. So, and you all were patiently sitting here for a long time. So unfortunately, I got to have you reset that. But if you think you can do it in 15 minutes, I'll tell you that doesn't typically happen when it comes to disputes about billing and coding experts. But if you all talk about it and you agree that you've narrowed down the issues on that particular expert, but generally those hearings take 30 to 45 minutes.
Okay, well, then I'll do both of those things. I'll correspond with defense counsel and I will try in earnest to get 30 minutes, Your Honor.
All right, so Ms. Campione, you want to do the order resetting the trial? Let me give you the dates.
Yes, Your Honor. Yeah.
The dates for the docket will be June 9th, 2025, virtual pretrial on May 6th, 2025 at 1:30 p.m.
Okay.
And the parties will remain controlled by previously issued uniform trial order, and you need to put the exceptions in there, with the exception that plaintiff will make their accident reconstruction expert available for deposition within 30 days.
Yes, Your Honor.
And that the parties will coordinate a Daubert hearing or a hearing on the motion in limine, however you filed it, as to the billing and coding expert. But the motion relative to striking the billing and coding expert would be denied for the same reason that the accident reconstruction expert is going to be allowed. There's no really identifiable prejudice.
And I agree with that, Your Honor. And the only question I have is, can we be excused from pretrial tomorrow?
Yes, you can be. That doesn't mean you might not get a phone call from the JA saying where's my paperwork, because I don't have time for that.
Fair enough.
All right.
Thank you, Your Honor. Maybe I can be excused.
Y'all have a good day.
Thank you.
Thank you, Janet.
All right, folks, the 11 o'clock hearing is Madriaga versus Lake County Towing, 2021 CA 9363, appearance for plaintiff. Now an appearance for plaintiff in Madriaga versus Lake County Towing.
Joseph Shaughnessy for the plaintiff, Your Honor.
Appearance for defense.
There's no one from the defense, Your Honor. This is the fee dispute with Attorney Pollack.
Arthur Pollack appearing for himself, Your Honor. Good morning.
Stenographer here, Judge. Brenda Browning from Legacy Reporting.
All right, do we have anyone else on this case?
Court reporter Aubriana San Martino on behalf of Milestone Reporting Company.
Okay, so you have two court reporters. Who do you want to keep?
Legacy.
All right, folks. So I took a look at your file. I see that we have a ongoing dispute about the attorney's fees. I have a motion for order to show cause or an amended motion for order to show cause. So tell me where we are on this.
Your Honor, you had a hearing on this on January 6th of this year. We were seeking to compel timesheets, cost ledger for Mr. Pollack that we had been requesting since October of 2024. And you ordered him to provide those records to plaintiff within 30 days. The records were not provided. It doesn't appear that he even attempted to start on creating timesheets or gathering the materials he needed until 4 days after your order. He sought no affirmative relief from the court extending that deadline. The order on the January 6th hearing, he objected to the entry of that order because he wanted to take the depositions of Mr. DeFreitas, Ms. Maradiaga, and Mr. DeFreitas' paralegal, Terry Lopez Padilla. The court did not order that, so we could not agree to that and submitted an order reflecting what the court ruled based upon the hearing transcript. His deposition was taken February 21st. He still did not have timesheets, cost ledger, and had not made a single time entry to start that process. So it is his burden to prove up his fees and costs in a case, and he has failed that burden. And we're here today for the evidentiary hearing. My client is in attendance.
Have you received anything on his timesheets as of today?
Not a single thing, Your Honor. As of February 21st of this year, when his deposition was taken, he had not made a single time entry on a single piece of paper to prepare his timesheets in compliance with the court's order.
Mr. Pollack.
Your Honor, good morning. There is a serious reason why I wasn't able to do that. And that serious reason is because pretty much a week after we spoke the last time. My whole family, including myself, except for like one child, got stricken with a serious case of flu that put me out for about 2 weeks. Within the time frame, my daughter also got into a serious car accident where the person that hit her actually died. I was under the impression I'd be able to get the phone records to be able to substantiate the time that I would need to show. However, it seemed that Spectrum Mobile, the phone company that provides service for my cell phone, wasn't able to give it to me right away. So I had to go through a few steps in order to be able to get them, and I finally did get them. I finally did get the records. They only go back to 2020, and Spectrum Mobile said that they wouldn't be able to give me anything earlier than that. We needed records from, I believe, February, March 2018 for the phone calls. I do still, so I was able to get those records, but just recently my computer died, and I need to extract files out of this computer now. It just seems that I've had a bad month and a half, but I would like you to extend some time to be able to get me situated. You know, my illness put me back by a couple of weeks. Morgan & Morgan is a large company. I work by myself pretty much. And I have clients that are needed to help. You know, I had to attend to my clients' needs in this time as well. That's why it's
Did you provide any documentation of any of this to them?
I do have records of my family being ill, and there's actually an article in the news about
My
the
question was, did you provide any documentation of anything you're saying to opposing counsel?
I didn't provide any documentation, but I don't think I did, but I told the opposing counsel about the bad case of flu during my deposition.
Okay, so you told me that you had the flu for 2 weeks, except the hearing was in the beginning of January. It's now.
Yeah, and this happened right after that.
Okay.
So, and also, like, towards the end
Your deposition wasn't even taken till February 21st, 6 weeks later.
Right, but I was sick for like 2 weeks at the end of January.
Okay, so that took you toward the end of January. You still had the entire month of February, and you didn't produce anything to them.
I was trying to get the records. See, I thought that I would be able to get the records for the phone pretty fast, but I wasn't able to. They told me you can't. You have to go through a specific process, like submit notarized paper to be able to get the records, and it takes them time to approve. You have to connect with their legal department. They approve, and only then they send you the records. I do have the records now.
If you have those records, why didn't you send them to them? I just asked Mr. Shaughnessy whether he'd received anything to date, and he said nothing.
Those would only be my records of my telephone company. I mean, with a bunch of phone numbers that from 2020 that I've communicated by voice and text. That's all it would be. And regarding to me not doing anything for the timesheets, I mean, I know that Ms. Maradiaga called me from the scene of the accident the day of her getting into an accident, when I told her exactly what to do, what not to do, the documents to take, what kind of medical attention to seek after the accident. I spent about a good hour on the phone with her that day. So there's my first entry.
Mr. Shaughnessy.
Your Honor, at this point, we'd ask that his lien be discharged. He's in violation of the court's order. He's had ample time to provide these records. His deposition was taken on February 21st. Mr. Pollack didn't do any legal research, didn't do anything to determine whether he had to provide timesheets from the time they were first asked. He did not provide a copy of Ms. Maradiaga's file pursuant to her request back in 2021. That request was followed up by Mr. DeFreitas. He acknowledged in his deposition that pursuant to Florida Bar Ethics Rule 88-11, he had an obligation to turn over that file. In the Searcy case that everyone is very familiar with regard to quantum merit, one of the factors to consider in the totality of circumstances is whether the actions of the attorney seeking fees, their actions had a detrimental effect on the plaintiff. In this case, it absolutely did. Mr. DeFreitas and Morgan & Morgan, as well as myself, had to totally recreate the file. Since he failed to turn it over, he acknowledged he had an obligation to turn the file over and simply did not do it, stated he forgot and that Mr. DeFreitas should have reminded him of that obligation. He has turned over copies of his file materials. He's not entitled to a fee for a variety of reasons, first being in violation of court order, not providing what is needed in order to prove up his fees. But second, he represented Mrs. Maradiaga as well as the companion case in this crash, and it never obtained conflict waivers from Ms. Maradiaga or Mr. Montanez, and it therefore is not entitled to a fee because he violated an ethical rule in that regard, explaining that these two plaintiffs were going to be fighting over a limited portion of a pie. And Ms. Maradiaga was absolutely, totally unaware of that. She was also unaware of the fact that there was a conflict because the defendant in this case was raising a comparative negligence defense against her, which could create a situation where her and Mr. Montanez would have adverse positions. So Mr. Pollack should never have handled any of these cases without those conflict waivers, and the failure to obtain it requires his fee to be not only discharged with regard to Ms. Maradiaga, but arguably he's required to disgorge any fees he obtained on behalf of Mr. Montanez. And I filed a memorandum of law in that respect as well, Your Honor. I mean, we could go through this process. I don't think he's met his burden. It is his burden to prove. The Blake v. Murphy case, 736 Southern 2nd 745, said the case law is clear that fees cannot be based solely on testimony of the attorney claiming the fee, but rather expert testimony must be offered substantiating the fee. Mr. Pollack has not provided an expert here today to do that. Further, reconstructed time records are allowed. We don't have any in this case, but something more than wild guesses are necessary to support an award of fees based on reconstructed records. He's been given ample time to provide these things from the court. He continues to talk about the phone records. I would point out that pursuant to his deposition, he said that he was so ill, for which he did not seek any medical attention over the course of this flu, that he was actually incapable of calling his phone company to get these records, and he did not attempt to obtain the records until 4 days after this court's order expired. And when I asked him if he was going to respond to the order to show cause, he said on February 21st that he was going to do that today. He has still not done that. How Mr. Pollack has acted in this fee dispute is the same way he handled Ms. Maradiaga's case. It's one delay after another delay after another delay with an excuse on why he can't do what he says he's supposed to do or why he can't do what he was hired to do. So we would ask that his fee be discharged to allow this case to be closed and let Ms. Maradiaga move on through life as well as my law firm.
It appears, folks, that Mr. DeFreitas, on behalf of Ms. Maradiaga, had been requesting this information as far back as 4 years ago. And then subsequently, there's been ongoing litigation over this since the settlement of this case in December of 2024. As of today's hearing, there is no documentation of any time that's been provided to Ms. Maradiaga. And
I provided the file, Your Honor.
There's no expert here to testify as to those fees. I'm not going to get into the issue of the waiver of conflicts. That isn't outlined by the motion that's here right now. It's focused on the failure to provide the documentation. It is Mr. Pollock's burden of proof to establish that. Mr. Pollock has failed to establish either the quantum merit value of his services or any reasonable basis to extend time for providing that information, in as much as he's had 4 years to provide that information, and very specifically has been under a court order to provide that information since January of this year and has failed to do so or request an extension of time via a motion to the court with supporting documentation of the reasons why and the good cause. Therefore, the lien will be discharged. Send me an order to that effect. 33 Orange at 9thcircuit.org. Anything else I can do for you folks today?
No, thank you, Your Honor. Thank you for your time.
You all have a good day.
You too as well. Thank you.
Thank you, Your Honor.
All right, Rebecca, the 2 o'clock hearing for today has been canceled.
Yes, ma'am. Can you hear me, Judge? Because you're frozen on my end. But
I can hear you.
okay.
All right.
So 2 canceled. Okay. We'll see you at 1:30 then.
Yep, we'll see you at 1:30. This will conclude the morning docket for Division 33.